My prediction, bear in mind I've been wrong in the past and I'll be wrong again in the future. I am predicting that Fuct is not going to be granted a trademark. Not going to be
granted a trademark.
Well, I was wrong.
But kinda wrong for the right reasons.
Viva Frei, Montreal litigator turned YouTuber. I do these things called vlogs, VLAWGS.
You should all know what they are by now.
If I look tired, it's probably because I am. Yesterday we went to an amusement park in Montreal called La Ronde.
On Saint Jean-Baptiste Day.
Saint Jean-Baptiste Day is a provincial holiday in Quebec. We waited 2 hours in line for one ride. 2 hours in line for one ride.
We waited 2 hours. 2 hours for this. You ready?
Oh my God! We're upside down! Oh my God! We're upside down! We're upside down!
Incidentally, if anyone wants to see every ride from La Ronde, POV from the front row of the roller coaster, check out the montage I'm going to make on my other channel called Viva Random. I'll link it right here. Today we are breaking down the Supreme Court decision in the Fuct trademark lawsuit, which is fantastically interesting. I did a video on this a while back when we were in Washington, D.C. at the actual Supreme Court. I'll link that video right here. No, here, right up here. Check that video out first, because in that video you will see a breakdown and my prediction, which did not come to fruition, but it kind of did, because my prediction was kind of one of the dissenting opinions, but we'll get there. Yanko versus Brunetti is the United States Patent and Trademark Office versus Brunetti, the owner of the trademark Fuct, Fuct for the purposes of this video, because I don't want this video getting flagged by YouTube's algorithm. Fuct, a clothing line that has existed since the 70s, and apparently it stands for Friends You Can't Trust. It's pronounced another way, which is the past participle of struck in German, from what I understand of the origins of the term. Fuct is a clothing brand that has existed for decades, but it was only recently that they applied for a trademark from the USPTO, the United States Patent and Trademark Office. Their application for registration of the trademark Fuct was initially rejected by the USPTO on the basis of certain provisions of the Lanham Act that prohibit registration of immoral or scandalous marks. Fuct obviously being immoral or scandalous because it's a terrible swear word. They contested the refusal of the registration all the way up to the Court of Appeal, and the Court of Appeal determined that those provisions of the Lanham Act were in fact unconstitutional. And the USPTO took the decision all the way to the Supreme Court to determine if the prohibition of registration of scandalous or immoral marks is in fact unconstitutional, and that's what brings us here today. In my initial video on the subject, I predicted that the Supreme Court was in fact going to determine that Fuct could not be trademarked on the basis that it was in fact scandalous or immoral. My prediction, bear in mind I've been wrong in the past and I'll be wrong again in the future. I am predicting that Fuct is not going to be granted a trademark. And the reason why is because this will invariably open a floodgate to variations of spelling of otherwise offensive and obscene words. Fuct is just an alternative spelling to an objective, well-known, well-established swear word, and I suspect that the Supreme Court might actually decide that it is not a First Amendment issue because nobody is depriving the brand of using the term Fuct. They are just being deprived of registering it as a trademark. They are being denied commercial protection, not freedom of expression. Now, I was wrong, period, full stop.
But
I was kind of wrong for the right reasons, because a part of my reasoning is in fact still found in the majority decision, and it's also found in some of the dissenting opinions. But I was wrong in law because the question was not limited to the brand Fuct per se. The question in law related to the unconstitutionality of the restrictions on immoral or scandalous marks, because what does that mean in law? And the legal backdrop of the Fuct Supreme Court decision goes back to the previous decision of Mattel versus Tam. And we touched on that in my initial video on the subject as well. That was an Asian rock band who wanted to call themselves the Slants. And the registration of that mark was previously refused by the USPTO on the basis of a refusal of registration of marks that were disparaging in nature. And the Supreme Court determined in that case that the prohibition of registration of marks that were deemed to be disparaging under the Lanham Act was unconstitutional in that it violated the First Amendment freedom of speech. Which brings us to the Fuct situation, where the Supreme Court is being called upon to determine the unconstitutionality of the scandalous and immoral prohibitions under the Lanham Act. And what conclusion did the Supreme Court come to? A lot of people are reading the headlines in this decision and saying, this is just another example of how society is degrading. Now they can register Fuct, they can register Shiad, and all sorts of other things in the future. That is not exactly an accurate summary of the Supreme Court's decision. In fact, the Supreme Court was not in love with the Fuct brand. And the judgment is not a moral approval of the brand Fuct in and of itself. The judgment is in fact something of a notice to government to fix the vague and unconstitutional provisions of the Lanham Act, if in fact what they want to do is prohibit the registration of objectively offensive terms in form and not in expression. But we're getting ahead of ourselves, so let's just get into the decision and break it down page by page. 2 terms ago in Metal, this court invalidated the Lanhams Act bar on registration of disparaging trademarks. Although split between 2 non-majority opinions, all members of the court agreed that the provisions violated the First Amendment because it discriminated on the basis of viewpoint. And this is what the decision is about. Discrimination by the government office as relates to the viewpoint being expressed in the trademark is not constitutional. At page 4, the Supreme Court states as follows. The justices thus found, in the Tam decision, common ground in a core postulate of free speech law. The government may not discriminate against speech based on ideas or opinions it conveys. And at page 5, the court goes on to write as follows. If the immoral or scandalous bar similarly discriminates on the basis of viewpoint, it must also collide with our First Amendment doctrine. The government does not argue otherwise. And this is the crux of the decision and the declaration of the unconstitutionality of the immoral and scandalous bars on trademarks. They don't just bar terms like Fuct or Shiat or Biatch. In other words, the prohibition on scandalous or immoral marks doesn't just relate to the form of the mark, it relates to the substance of the mark. In other words, you have the government issuing or refusing to issue trademarks on the basis of its approval or disapproval of the substance of the viewpoint being issued in the mark. Not necessarily the case in Fuct per se, but necessarily what follows from the ambiguity of the drafting of the Lanham Act's prohibition on immoral or scandalous marks. It includes the Fuct, but it also includes marks based on a viewpoint that the government may not approve of. Examples of the USPTO refusing trademarks not based on the form of the mark, but rather on the viewpoint of the mark include the following. Pages 6 to 7. Here are some examples. The PTO rejected marks conveying approval of drug use. You can't spell healthcare without THC for pain relief medications, marijuana cola, and cocaine for beverages, because it is scandalous to inappropriately glamorize drug use. But at the same time, the PTO registered marks with such sayings as dare to resist drugs and violence and say no to drugs. Reality is the best trip in life. And here we see examples where registration of certain marks was refused on the basis of the scandalous and immoral provisions of the Lanham Act, but not on the form of the mark, but rather on the viewpoint expressed in the mark. And that is what is unconstitutional in that it violates the First Amendment of free speech. And at pages 8 and following, the court discusses whether or not the USPTO's methodology is viewpoint neutral. Viewpoint neutral meaning that it either grants or refuses to grant trademarks not based on the substance of the viewpoint, but rather on the form of the mark, so not dependent on the concept or the ideology or the viewpoint expressed in the mark. And the court concludes that the USPTO doesn't even argue that it is in fact viewpoint neutral. The USPTO argued that these provisions of the Lanham Act could be read in a manner so that they only refuse registration of trademarks that are immoral or scandalous in form but not in viewpoint. And they basically invite the court to treat all those previous examples as mistakes. And at page 9 of the judgment, the court explains why it can't accept this line of reasoning from the USPTO. But we cannot accept the government's proposal because the statute says something markedly different. This court, of course, may interpret ambiguous statutory language to avoid serious constitutional doubts. But the canon of construction applies only when ambiguity exists. We will not rewrite a law to conform it to constitutional requirements. The Supreme Court is not a legislator and it is not there to rewrite laws so that they become constitutionally compliant. That is the job of the legislators. The job of the Supreme Court is only to interpret the law. If the law is unconstitutional, the court strikes it down and it's up to the legislators to rewrite it in a manner that is constitutional and acceptable. And that's what the Supreme Court is basically inviting the legislator to do. The court ultimately comes to the conclusion that once they have found that the provisions of the Lanham Act, as relates to immoral or scandalous marks, aims at the suppression of views, it's not going to justify the unconstitutionality of that provision on the basis that it also captures immoral and scandalous marks in form. And they ultimately come to the following conclusion at page 11. But in any event, the immoral or scandalous bar is substantially overbroad. There are a great many immoral and scandalous ideas in the world, even more than there are swear words, and the Lanham Act covers them all. In other words, the Lanham Act doesn't just prohibit registration of trademarks such as Fuct. It prohibits the expression of viewpoints such as you can't spell healthcare without THC, which is a violation of the First Amendment and therefore unconstitutional and must be struck down. And speaking to the point I made earlier that this decision basically reads like an invitation to Congress to legislate prohibitions that are constitutionally acceptable, in Justice Alito's concurring opinion he writes as follows. Our decision does not prevent Congress from adopting a more carefully focused statute that precludes the registration of marks containing vulgar terms that play no real part in the expression of ideas. The particular mark in question in this case could be denied registration under such a statute. The term suggested by that mark is not needed to express any idea and, in fact, as commonly used today, generally signifies nothing except emotion and a severely limited vocabulary. The registration of such marks serves only to further coarsen our popular culture, but we are not legislators and cannot substitute a new statute for the one now in force. That is to say, hey Congress, if you want to pass a law that just bans vulgar terms that themselves do not convey or express any idea that is constitutionally protected, go ahead and do so. But as drafted, the Lanham Act in banning scandalous and immoral marks doesn't just cover vulgar terms, it covers expression of ideas that the government does not agree with. And that is a violation of the First Amendment. And when I jokingly said in this video that I was wrong, but wrong for the right reasons, it goes to something that Justice Roberts says in his partially dissenting opinion. In my first video on the subject, I said that refusal of registration of a trademark is not necessarily a violation of the First Amendment or free speech, because it doesn't prevent the mark owners from expressing themselves or even from using their mark. All that it does is prevent registration of those marks. It doesn't necessarily prevent use of those marks. So it is not necessarily infringing on someone's right to freedom of speech. It is basically just saying that the government does not have to approve or sanction it. And this is effectively what Justice Roberts writes in his partially dissenting opinion. I also agree that regardless of how exactly the trademark registration system is best conceived under our precedents, a question we left open in TAM, refusing registration to obscene, vulgar, or profane marks does not offend the First Amendment. Whether such marks can be registered does not affect the extent to which their owners may use them in commerce to identify their goods. No speech is being restricted. No one is being punished. The owner of such marks are merely denied certain additional benefits associated with federal trademark registration. The government, meanwhile, has an interest in not associating itself with trademarks whose content is obscene, vulgar, or profane. The First Amendment protects the freedom of speech. It does not require the government to give aid and comfort to those using obscene, vulgar, and profane modes of expression. And it is a very interesting line of reasoning. The government is not limiting any individual or corporation's right to free speech. They are just basically not sanctioning speech with which they do not agree. But alas, this is a dissenting opinion on a non-core element of this judgment. And an important parenthesis to open up here. It's not because a trademark has not been registered that the owner of that mark does not have legal protections. There are certain protections of a trademark that exist regardless of whether or not that mark is registered, and those are known as common law protections of a trademark. Common law protection of a trademark exists when that trademark is being used. Period. That being said, those protections are generally geographically much more limited, and they don't give you the benefit of certain protections that exist under the law by virtue of your trademark being registered. Registration constitutes prima facie evidence of the validity of the trademark, because as I said in my previous video, some trademarks are not going to be recognized for various reasons, some of which might be because the terms are just too generic to be recognized as a trademark. Holy cow, I gotta show you something, hold on. Knife Mate. This is actually a product that my uncle-in-law makes. It's called Knife Mate. It looks like a wooden board because it is. Vlog dog is coming. Vlog dog, get over here, boy. How you doing? You had a good weekend? Get out of here. It looks like just a regular piece of wood. It's got some little sticky tape on the back, except there's magnets in it. So you can use it to hang knives on the wall, and when you want to use it, you take the knife off, put it back on. An amazing idea, right? Of course. Knife Mate as a mark for this particular product may be too generic for registration purposes. Now, I have not given my uncle-in-law any legal advice on this subject. I do not give legal advice to friends or family. It never goes anywhere good. But just because this trademark is not registered, it does not mean that my uncle does not have common law protection of this mark, which he does. Incidentally, if you want to get this particular product, I'm going to create an affiliate link on Amazon because it's being sold on Amazon and it's totally cool because from what I understand, I get like a percentage of every sale that goes through on Amazon if you click through that link to get this particular product or any other product in that shopping sequence. It's totally cool. All right, and thus ends my shameless promotion of my uncle-in-law's product, which I think is fantastic. Made in Canada, awesome stuff. If you like my content and my channel, be sure to like, share, subscribe, leave a comment below. That type of action on a video gets YouTube's algorithm going and seems to make the video more recommendable to other people. And now you know your vlog. Peace out. Boom!